Hi, my name is Alex, and I'll be going over Oberdorf versus Amazon. So, this product liability case explores whether an online marketplace like Amazon can be treated as a seller under state tort laws, raising significant questions about liability in the digital age. Traditionally, product liability has applied to manufacturers and retailers in the physical chain of distribution. Platforms like Amazon complicate this model by facilitating sales without always taking ownership of the goods. As Amazon often handles payments, storage, and shipping for third-party products, courts are increasingly asked to decide whether this involvement makes the company legally responsible when defective items cause harm. The issue is especially pressing when third-party sellers are untraceable or based overseas, leaving consumers with limited avenues for recourse. Recognizing online marketplaces as sellers could push them to implement stronger safety measures while also reshaping the legal and regulatory frameworks that govern e-commerce. This case plays a pivotal role in defining platform accountability and consumer protection in an increasingly digital marketplace. First, let's gain an understanding on a few core legal principles to help in analyzing this case. So first, starting with product liability, strict liability for injuries caused by defective products sold by sellers. This holds sellers accountable regardless of fault. Strict liability, liability without proof of negligence for injuries caused by defective products, applies only to sellers under 402A of the Second Restatement of Torts. And last, Communications Decency Act, or CDA, Section 230. It limits liability of or for online platforms acting as publishers. Amazon argued CDA shields it from the liability for third-party vendor products. Now getting into the parties in complaint. So starting with the plaintiff, Heather Oberdorf and her husband, defendant Amazon, in the complaint being product liability and negligence. Oberdorf lost sight in one eye due to a defective dog collar sold by a third-party vendor through Amazon. Now getting into the undeniable facts of the case, starting with the purchase of the dog collar. Oberdorf purchased a dog collar via Amazon Marketplace listed by a third-party seller named the Furry Gang. During use, the collar's D-ring broke, causing the retractable leash to snap back violently. The snapping leash injured Oberdorf's left eye, resulting in permanent blindness. And lastly, the vendor is unreachable by both Oberdorf and Amazon. Now some questions regarding legal conflicts and issues. Can Amazon be considered a seller under Pennsylvania's product liability law when items are sold by third-party vendors through its platform? And does CDA 230 protect Amazon from liability for defective products sold through its platform, despite its involvement in the transaction? District Court ruling. The lower court initially ruled that Amazon did not have seller status and that claims were barred under CDA 230, setting the stage for appeal. So, the Third Circuit Court of Appeals carefully applied the Muser versus Millsmere Auction Co. four-factor test to determine Amazon's seller status. So this four-factor criteria included one, being only actor available, meaning Amazon was the sole party available for the plaintiff to seek redress. Two, promote safety. Holding Amazon liable would encourage greater product safety on its platform. Three, prevent defects. Amazon is better positioned to prevent defects through its control over listings and vendors. And four, distribute costs. Amazon can distribute costs of liability via vendor fees or compensation agreements. The court highlighted Amazon's extensive involvement, including payment processing, order fulfillment, and control over listings as strong evidence supporting its classification as a seller. So now getting into CDA's ruling. The Third Circuit's interpretation of CDA Section 230 was a pivotal part in this decision. CDA 230 did not shield Amazon. The court concluded that CDA 230 did not protect Amazon from strict liability claims related to its role in sales and distribution. CDA protect CDA protection is limited to editorial functions, so publishing third-party content, not active involvement in actual product transactions and fulfillment. Amazon's actions went beyond publishing. So now we've been waiting for the outcome. On July 3rd, 2019, the Third Circuit panel ruled that Amazon may be held strictly liable as a seller. Summary judgment in Amazon's favor was vacated and the case was sent back to lower court for further proceedings. On August 23rd, 2019, the full Third Circuit Court of Appeals agreed to reconsider the panel's ruling. This action effectively vacated the panel's decision and created uncertainty regarding the case. So to simplify, a panel of judges initially ruled that Amazon could be held strictly liable as a seller for a defective product, reversing a previous win for Amazon. However, August 23rd, 2019, the full Third Circuit Court decided to rehear the case, which canceled the earlier ruling and left the final outcome undecided. So through this case, some key learnings are platforms may be subject to product liability laws, even with third-party vendor models. They control key aspects of the sale. Liability extends to platforms that leave consumers without recourse when vendors are unreachable. And lastly, CDA 230 does not shield platforms from liability arising from their direct transactional and distribution roles, only from their editorial functions. Thank you.